Hi, everybody. Welcome to part three of our series on the Supreme Court. This one is about what it's like to argue in front of the court. So, just as an example, let's say someone burns an American flag. There, of course, is a real case about that, Texas v. Johnson, but that's sort of the idea I'm going to take for my example. So, let's say a man, Mr. Williams, burns a flag. Uh, he's arrested and he's found guilty of burning a sacred symbol. Well, you might guess he's not going to be satisfied with that verdict. He's going to want to appeal it. So let's say that this case goes the whole way through the appeals process and makes it to the Supreme Court. Anytime a case makes it to the Supreme Court, it gets a lot of press. And one of the first things the lawyers will do is submit their briefs. So the first vocab word for today is brief. It's a written statement that tells the legal arguments, the facts, the precedents. This is just the lawyers putting in writing what their argument is going to be for the case. So this is for the judges to read ahead of time. It helps them prepare for the trial. There's actually no video in the Supreme Court. They don't allow video, so all we get are these drawings. Some of them look kind of funny. Justice Gorsuch over there kind of has a weird look on his face. But this is all we get because we're not allowed to have video. Not that long ago, someone made a dog Supreme Court. And I know if you go on YouTube, they have videos of these dogs who are all supposed to be a Supreme Court justice, and they have the audio of real Supreme Court cases. So we have audio of these cases, but no video. So in the absence of video, they use these dogs. It's kind of interesting if you want to see, well, I guess rather hear a Supreme Court case and have some pretty clever visuals along with it. I don't know who did this or how they did it, but in the absence of video, all we have is audio and some pictures. So in the case I'm kind of making up here, let's say Mr. Darrow is the defense lawyer. So his written argument, his brief, would argue that Mr. Williams has a right to burn the flag under First Amendment free speech. So let's say Mrs. Jennings is the prosecution. She would be representing the government that arrested him. So again, she's going to submit her argument, her brief, that says the flag is a sacred symbol. It should be preserved and not vandalized. Another thing that will happen in Supreme Court cases is this vocab word amicus curiae. A lot of things in the law are Latin, so the literal translation is friend of the court. It just means that people who have nothing at all to do with the case have still submitted briefs that they think will add information. So this case was about flag burning. So two groups that might want to submit a brief are the VFW and the ACLU. The VFW is the Veterans of Foreign Wars. So obviously, if these folks are war veterans, the flag's a very sacred symbol to them. They might submit a brief as to why you should never burn a flag. The ACLU stands for the American Civil Liberties Union. They tend to fight for the rights of citizens of the United States. So they might have some arguments about why they think you should be able to burn the flag. What happens next in the case is both lawyers will present their oral arguments. So that's your vocab word. It just means it's a verbal presentation to the judges. Both lawyers are limited to 30 minutes. So when you argue before the Supreme Court, the justices are pretty strict. You get 30 minutes. They have a rule at the beginning, you're promised time to talk uninterrupted. I think it's only like 2 minutes. And then the judges will interrupt you with questions. Also, if you're a lawyer before the Supreme Court, there's a light system. So those first 2 minutes, when it's just your floor to talk, there's a light that indicates that. And then when that time is up, a different light comes on and the judges will start questioning you. I've heard the Supreme Court justices can be kind of rude. They'll just interrupt you, start answering their questions, and then when your light runs out, time's up, you have exactly 30 minutes to present the case. Uh, by tradition, on Friday, the justices meet in a conference room to decide the case. It's a secret closed door meeting. There's no audio of any of this. By tradition, all the justices shake hands first. I have an old tradition. And there's a discussion and then there's a vote. So in the Supreme Court, the majority wins. So it doesn't have to be unanimous. It doesn't have to be 9-0. 5-4 will win a case. So if we're following the example set in the famous Texas v. Johnson case, so an example is that vocab word is precedent. If you're following that precedent, you would expect Mr. Darrow to win this case, that the right to burn a flag is protected by free speech. This is kind of an old vocab word, but just a refresher. Remember, after the Supreme Court rules, they have to write an opinion. An opinion is a written explanation for why the court ruled the way they did. There's 4 types of opinions. So the easiest one is unanimous opinion. That just means all 9 justices agreed. As you might guess, it's hard to get 9 people to agree on anything, so that one doesn't happen too often, but it's easy because you only have to write one opinion because they all agreed. What's much more common is majority opinion. That's written by one of the justices who was on the winning side, and it's just explaining why they ruled the way they did. Concurring opinion is the 3rd type of opinion they might have to write. Con usually means like with or both. I always think like chili con queso. It's like chili with cheese. Con is always with. So this is written by a judge that agreed with the other judges, but for a different reason. Concurring opinion, you agreed with the other judges, but for a different reason. So if we said the majority opinion in this case, the flag burning case, is the majority of judges said it was a free speech issue. Maybe one justice said, no, for me it's a petition the government issue, or for me it's a right to assemble issue. Since he agreed, but for a different reason, he would write the concurring opinion. And then dissenting opinion, those are pretty common. Those are written by judges who disagreed with the majority. So in this case, a dissenting opinion will be written by a judge who thought they got it wrong, who thought, you probably should not be able to burn a flag. So how do they decide who writes this, who gets this essay assignment? A justice may be assigned to write an opinion by the Chief Justice. And remember, they have their helpers. They call them law clerks. They can help write the opinions. All the other justices usually read the opinion just to make sure it's what they want before it gets published. So the Supreme Court has a really big role in shaping public policy. I think a bigger role than a lot of people realize. A lot of people think, well, all the power is in the executive branch, the president, or in the legislative branch, the Congress, but the Supreme Court can play a big role in our public policy. They do it in 3 big ways. One is judicial review, 2 is interpreting the meaning of laws, and 3, they can overrule past court decisions. So let's break down these 3 things. What does this mean? So what does judicial review mean? This is an old vocab word. Excuse me. I would say one of the most important vocab words for the whole unit. Judicial review is deciding whether or not a law is constitutional. So Washington, D.C. tried to pass a law that said you couldn't bring a gun into the city. Is that constitutional or not? The Supreme Court ruled no, that'd be a violation of the Second Amendment. So this is the Supreme Court's power to see if laws passed by Congress are constitutional. If you remember, again, this is kind of like an old vocab word. It's called the precedent. And remember, the precedent for doing this, the first case where they set the example that they could overrule overrule acts of government is Marbury versus Madison. So the second way the Supreme Court has a big power on public policy is in interpreting the law. So what do we mean by that? A lot of laws are vague, so it's up to the Supreme Court to say, what does a law really mean? So for example, there's the Americans with Disabilities Act, and that law says that places have to provide reasonable access to their store for customers with disabilities. So what exactly does that mean? Does that mean a store has to have special parking? Does that mean a store has to have an elevator if it has a second floor? So the Supreme Court says what a law actually means. I know if we go back to the Second Amendment promises the right to bear arms, but that's pretty vague. We've talked about a lot in class, well, what counts as a weapon? So the Supreme Court decides what these laws actually mean by making them more specific. So another famous law in our country is the Civil Rights Act. This was passed in 1964 by President Johnson, and it says you can't discriminate on anyone based on their race, color, sex, religion, or place of origin. It's a very important law, but it's also kind of vague because it begs the question, well, what counts as discrimination? So some cases are pretty obvious. Like, of course, a place can't say, well, we're not going to hire you based on your sex. Or a place, of course, can't say, well, we're not going to hire you based on your race. But some cases the Supreme Court has looked at have been a little more vague. So there have been cases where a student has moved into a district who spoke a different language. Well, is the school district required to provide education in that language? Or there have been cases, some military institutes have only allowed men to attend. Well, what if a woman wants to go? Or in terms of the military, what if a woman wants to serve in combat? Is that a violation of her civil rights? I know there have been cases where there have been restaurants that have traditionally only hired women as waitresses. Well, is that a violation of civil rights for men? I know they've had cases where businesses didn't want to hire a woman if they knew she had young children because they thought she'd have to take off work more often. So, are these cases where someone's being discriminated against, and are they therefore covered by the Civil Rights Act of 1964? We did this a long time ago with the 14th Amendment, but maybe you remember there's usually three ways that the court looks at to see if you've been discriminated against. One question the court will ask was, did the person have a good reason to discriminate against you? In other words, was it something you did? So, like if you got like fired from your job and you said, well, they fired me because I was a woman, maybe the court will say, well, they'll ask your employer, is that why you fired them? And the employer will say, well, no, they were late for work. So was there a good reason that the place did whatever they did to you? Another thing they'll look at is, were you discriminated against based on something you could change? So in our case, where the person was fired for being late to work, she could change that. She could just show up earlier. But of course, if you were treated a certain way because of something you couldn't change, like your race, that's something that would probably be covered by the Civil Rights Act and be illegal. Another thing that the court will look at, were you treated differently in such a way that took away constitutional rights? If your constitutional rights were violated, that's a much more serious case. So did someone take away your right to free speech? Did someone take away your right to express your religion? So just to say it again, in discrimination cases in court, sometimes are really hard to prove because it's hard to prove exactly why someone may have treated you differently. But the three things the court will look at, did they have a reason for it? Was it based on something you could change? And is it something that violated your constitutional rights? So this is just all a different way of saying the Supreme Court gets to decide what laws and even parts of the Constitution actually specifically mean. So the third power we said the Supreme Court has is they can overturn past court decisions. Sometimes the Supreme Court reverses themselves, and sometimes the Supreme Court reverses lower courts. They do not often reverse themselves, and that's the idea on the slide here. Stare decisis. Again, it's a Latin word. Because of that, it kind of makes it hard to remember. But I think of it, that word decisis sounds like decision. So it's the idea that the decision should stand. So it's the idea that the Supreme Court rarely reverses themselves. Whatever the Supreme Court decided in the past is usually going to be the law for the future. Um, Sometimes they reverse themselves, but usually they don't. Usually, whatever they decided in the past is the precedent, is the example for the future. That idea is stare decisis. Let the decision stand. And another old vocab word, but still a good one, is precedent. Precedent is a decision that sets an example for all other cases. So the Texas v. Johnson case with flag burning, that sets the precedent that you have the right to burn a flag. These are all important concepts because they add stability to our law. Um, they are a guide for how judges and how police officers operate. So that's it for this lesson. I hope you liked it, and I'll see you next time.